Hello, this is Miss Mason Explains Civil Law. All right, so what is civil law? Let's take a look at some pictures. So here we see someone pushing another person. Here we see an x-ray with some scissors in someone's chest cavity left after surgery. Here someone was pushed off of their ladder when they were painting a house. We have divorce. Uh-oh. And we have someone that is tripping and falling on a banana peel that was left on the ground. So what all do these have in common? Well, they can result in a civil court case. Okay, so let's take a look. What is civil law? Well, civil law deals with a dispute between individuals or a negligent act that cause others harm. Okay. So we see these two angry people. There's a dispute between two individuals. Okay, but it can also involve negligent acts. Those are acts that are done because you didn't do something. Negligence. You didn't do something that you were supposed to do, and that caused other people harm. Okay? Civil law typically involves money, it involves contracts, property, personal injury, divorce, or child custody. All right? So in these pictures, you see personal injury compensation. So the gentleman who fell off of the ladder while he was on the job painting someone's house, personal injury. So maybe the business that he works for owes him money. Okay? Family law, we're talking about child custody, adoption. If you're having issues with child protective services, family law is where you're going to see those type of civil law cases. And then divorce. If any of your parents have gotten divorced, your parents would have went to a civil court case. Okay? All right. Now, civil law, easy way to remember civil law is when you say, I'll sue you. So when you sue someone, you're going to go through the civil law court system. Okay? All right, so let's take a look at elements of civil law. So, in criminal law, we were talking about the prosecutor versus the defendant. Well, in civil law, we talk about the plaintiff against the defendant. And the plaintiff has the goal of receiving some type of payment, money, in return for damages caused by the defendant. Now, remember how we were talking about in criminal law, the burden of proof is beyond a reasonable doubt? Well, in civil law, it's preponderance of evidence. Okay, so it's the responsibility of the plaintiff to provide that evidence. Now let's watch this video about preponderance of evidence.
Unlike most criminal trials where the prosecution must prove the defendant committed a crime with clear and convincing evidence or beyond a reasonable doubt, civil cases have a lower standard of proof, known as preponderance of the evidence. For example, if you were sued and the plaintiff alleged you trespassed onto their property, they would only need to prove it was more likely than not that you trespassed, not that it was absolutely certain. Now, some judges have explained the standard of proof by using this football analogy. In a criminal trial, the prosecution would need to run the entire field and score a touchdown to get a guilty verdict. In civil cases, the plaintiff would only need to cross the 50-yard line.
All right. So, hold on one second. Okay. All right, let's go back. Okay. So, all right. We have the plaintiff against the defendant. Remember, who has the burden of proof? Preponderance of evidence? Well, that's the plaintiff. Okay? All right, so when we're looking at the burden of proof, preponderance of evidence, these are the three ways a case is going to end up if it went to a criminal or into a civil trial. If the plaintiff doesn't have enough evidence to support his case, then the defendant will win. If the defendant actually provides evidence that outweighs the plaintiff's evidence, then the defendant wins. So, again, the burden of proof is on the plaintiff. The plaintiff's evidence has to outweigh the defendant's evidence, and then the plaintiff will win. So what are some types of civil cases? Well, one of the types is a breach of contract. And a breach of contract is where a contract is not being honored or followed by one of the parties. A contract is a binding agreement between two parties. For instance, you have a wonderful house. You want to add a new bathroom. So you make a contract with a plumber to come in and add a sink, a toilet, and a tub. Well, you come back and the plumber only put in a toilet and a tub. Well, where's the sink? Well, that's a breach of contract. The plumber says, I'm not going to do it. Then you can sue. So that's a breach of contract. The other type of criminal or of civil cases is called a tort. And a tort is a civil wrongdoing that does not involve a contract. Okay? This is an unfairly causing someone else to suffer loss or harm. Okay? In this picture, we see the gentleman. He is pulling the office chair out from under this wonderful lady. She's falling back, and she might hurt her back. She might even break her back if she falls hard enough. And that is a civil wrongdoing. He is unfairly causing her to suffer harm. All right? So here's another video that explains torts.
A tort is a wrongdoing that results in injury to another person or damage to property. Torts differ from crimes in that crimes are punishable by the state in criminal court, whereas torts generally allow individuals to seek compensation for their injuries in civil court. Sometimes an act can be both a tort and a crime. For instance, threatening to seriously injure someone is, in tort law, an assault. The victim may be able to sue the perpetrator in civil court for compensation for the emotional distress caused by the assault, while the state may seek jail time in a criminal court. In order to win a tort lawsuit, the plaintiff must show that the defendant intended to cause harm to the plaintiff or had a duty to act in a particular manner, breached that duty, and actual damages or injuries occurred as a result of the breach.
All right. So for tort law, again, you have to prove that the defendant meant to do you harm. They fully intended to hurt you. Okay? So the two types, breach of contract and tort. Okay? There's a lot that goes into torts. All right? Okay. So now, how do civil court cases end? Now, when we were talking about criminal court cases, we were talking about if the defendant is found guilty or not guilty. Well, in civil court cases, a judge or a petit jury will decide if the defendant is found liable or not liable. Now, when we were talking about criminal court cases, you were either, you were punishable by jail time. Well, in civil court cases, your punishment is a fine, is a money. Okay, you have to pay for damages. Now, just like criminal court cases, a very small percentage actually go to trial. For civil court cases, only about 1.3 go to trial. Now, criminal court cases, again, a majority resolved through what? Exactly, plea bargains. Well, in civil court cases, they are resolved through something very similar, an out-of-court settlement. An out-of-court settlement is where both parties, the plaintiff and the defendant, reach an agreement out of the courtroom without the need for a trial. Now let's watch another video that will help us explain what is a settlement.
A settlement occurs when an agreement is reached between both sides in a lawsuit. A settlement can be reached at any phase in a lawsuit, even in the middle of trial, although they typically occur prior to trial. Parties themselves may engage in settlement negotiations on their own, or they may hire attorneys to assist in the process. Settlement agreements can be achieved through various means, such as mediation, arbitration, or face-to-face negotiations. Many cases today resolve their issues via settlement because litigation and trials can be extremely costly. Settlements offer parties an opportunity to resolve the legal wrong in a way that is mutually agreeable to both sides and much less expensive than traditional litigation.
And I guess just to explain, litigation is court
settlement
cases.
occurs-
Sorry. Okay. So litigation would be going to court. All right. All right. So let's go back to our video here. Okay. All right. So how do court cases end? Just remember, very small amount actually go to trial. A majority are resolved through out-of-court settlements. Okay. This is the end of Miss Mason Explains Civil Law. I hope you enjoyed it. Thanks.